This case, West Coast Hotel versus Parrish, represents a case after the shift or after the switch in time, um, and signals that the court going forward is going to be less amenable to substantive due process and liberty of contract. So in this case, the state of Washington provided a minimum wage law for women, um, and a female employee sued her employer to recover for wages that she claimed were owed to her based upon that state law. The employer in this case argued that he had a substantive due process right to contract with his female employees without state-based interference, so he did not have to apply the minimum wage to them. Um, if this case had been decided a year earlier, before FDR makes this threat, um, it would have gone the way of the hotel owner. But this case happens after that threat is made. In this case, Chief Justice Hughes, one of the judges who switched, writes the majority opinion, disagreeing, saying that the minimum wage law withstands liberty of contract or substantive due process. So Hughes writes that the minimum wage law has a legitimate end, the protection and health of women, and the law was a reasonable means of meeting those ends. And that was a legitimate legislative act that overrides any form of substantive due process, freedom of contract concerns. So the state, in this case Washington, had a legitimate concern over protection and health and safety of women. It legislated in that regard. It's legitimate legislation, and it overrides any sort of liberty of contract or freedom of contract that may exist. In fact, Hughes, in the opinion, goes so far as to say the Constitution does not even mention a freedom of contract, and as the Constitution deals simply with liberty and due process, and even further noting that liberty and due process are not absolutes, that liberty can be restricted and due process can be restricted. And so this idea of liberty of contract flowing from sort of some substantive due process is simply an anathema to the Constitution. And so as a consequence, the Supreme Court in Parrish very specifically overrules an earlier case that absolutely dealt with the same issue, that's Atkins v. Children's Hospital, and carves a path going forward as a method by which to, or as an example of how not to work and strike down this idea of substantive due process. Those individuals in dissent were exceedingly angry. Remember, these individuals in dissent had been winning up until last year and winning consistently. Justice Sutherland writes that the meaning of the Constitution does not change with the ebb and flow of economic conditions, and thus the Depression cannot change an interpretation of the Constitution. But obviously, it very clearly did. So despite Justice Sutherland's anger about this decision and this striking down of previous case law, the Depression very clearly played an intervening role. And sort of to harken back to a common theme that we're coming to now, is it absolutely possible that some of our long-held precedents can be struck down in the wake of changing health conditions and changing economic conditions? Absolutely. We've seen states innovating all across the country with regards to policy and policy delivery. I would imagine that we'll see courts quickly and soon evolving in this regard as well. Because as much as we like to argue that the Constitution should either be textually interpreted as written or with original meaning, and that's juxtaposed to the idea that the Constitution is a living document and that it evolves over time. The idea that the Constitution is a living document that evolves over time becomes much clearer when we're under times of stress. And during the Great Depression and through the examples of New Deal legislation, as a means to attempt to haul us out of that, the Constitution itself was put under significant stress, and previous precedents, at least according to the court, became untenable. and those precedents were overturned, and the main mechanism that established those precedents, substantive due process, fell into disfavor, not just among the legal academic community, but also among the court itself. So much so that substantive due process rights in the intervening years, in the 40s and the 50s even, substantive due process was not seen as a useful mechanism for the court. But that changes to a degree in the next case, where we see the reemergence of substantive due process. And we should very much take in notice how that reemergence should juxtapose with the tale of Lochner, and look at the mechanism by which is the mechanism that is working, substantive due process, in removal of the rights that it's incorporating into the Constitution.